So picture this, a massive legal drama playing out over the last great wilderness on Earth. We're talking about Antarctica in 1955, and the whole continent is at the center of this high-stakes showdown in the world's highest court. And believe me, this isn't just about a chunk of ice. This is about national pride, about deep historical claims, and a major clash over what sovereignty even means.
And it all kicks off right here, with this pretty formal, almost boring-looking letter from the British Embassy to the International Court of Justice, the ICJ. But don't let that dry, official language fool you. This piece of paper is basically the starting gun for a really bold, unprecedented legal move, an attempt to solve a nasty dispute not with guns and ships, but with lawyers and judges.
So, what was this whole fight really about? Well, to get why the UK took such a huge step, you gotta look at a map of Antarctica from back then. Because let me tell you, it was a complicated and, frankly, a very crowded place.
At the very heart of it, you had this problem. 3 different nations drew lines on a map over the exact same slice of the Antarctic Peninsula and all said, "That's ours." For the UK, Argentina, and Chile, these weren't just lines on paper. Oh no, these were deeply felt matters of national sovereignty. And it created this incredibly tense, frozen standoff at the bottom of the world.
Okay, so you've got this deadlock. Nobody is willing to budge an inch. So what does the UK do? They decide to change the game entirely. They take the whole fight from a regional squabble and blow it up into a global legal battle, hoping that the authority of the World Court can finally break the stalemate.
And they don't mess around. On that one day in May, they don't just file one case. They file 2 separate ones at the same time, one right at Argentina and the other aimed at Chile. The message they were sending was crystal clear. We think the law is on our side and we're ready to prove it against anyone who says otherwise.
And this right here really breaks down the basic disagreement. The UK's argument was basically, we found it, we planted flags on it, we've been running the place, so it's ours. Finders keepers, But Argentina and Chile had a totally different take. They argued from history and geography, saying they inherited the rights from the old Spanish Empire, and besides, look how close it is to them. It's practically their backyard. So you've got 2 completely different legal philosophies on a collision course.
So the UK made its big move, throwing all its chips on international law. The whole world was kind of waiting to see what Argentina and Chile would do. Well, Argentina was first to play its hand, and their response was going to bring the UK's whole strategy to a screeching halt.
And this is the moment the UK's plan hits a solid brick wall. In July 1955, this letter shows up from Argentina's ambassador. And they're not filing a counterargument. They're not getting their lawyers ready for a fight. Nope, they're just refusing to play the game at all. They completely rejected the court's authority to even hear the case in the first place.
This quote from their letter pretty much says it all. Their position was absolute. Our ownership of this land is a fact. It is not subject to discussion, and we're definitely not going to let any court decide on it. End of story.
Okay, so Argentina's out. Now all eyes turn to Chile. What are they going to do? Are they going to break ranks and actually argue their case in court? Or are they going to team up with Argentina and just kill the UK's legal dream right then and there?
Well, the answer came just a couple of weeks later. On July 15th, Chile sent its own formal no. The wording was a little different, but the message, identical. They said the court's authority was not applicable to territory that was, in their view, completely and absolutely Chilean. You could just hear the door slamming shut on a legal solution.
And this is the key legal problem that the UK just could not get around. See, the International Court of Justice isn't like a global police force. It runs on a simple idea, consent. It can only step in and judge a fight if every single country involved agrees to let it. Without Argentina and Chile saying yes, the court's hands were completely tied.
And this all happened incredibly fast. The UK files its case in May. By the middle of July, just a couple of months later, both Argentina and Chile have shot it down. The UK tries one last legal argument in August, but by March of the next year, it's all over. The ICJ just makes it official.
So how does this epic legal battle actually end? Well, since the defendants refused to even show up, there wasn't some dramatic verdict read by the judges. Instead, the whole thing just kind of fizzled out with the quiet, formal sound of bureaucratic machinery.
But wait, before that final word came down, the UK was not going down quietly. Faced with those 2 rejections, their legal team wrote up this really detailed and powerful rebuttal. They were making their case one last time, not just for the court, but really for the history books.
Their counterattack was super methodical. They argued point by point.
First, they said this idea that sovereignty can't be debated is just wrong. Courts do it all the time. Second, they pointed to a recent case where the ICJ did that exact thing. Third, they shot down the argument that just being close to land gives you a claim, saying that has no foundation in international law. And finally, they argued that refusing a peaceful legal solution goes against the whole spirit of the United Nations.
But no matter how good their arguments were, it couldn't change that fundamental problem of jurisdiction. And so on March 16, 1956, the end came in this simple little cable. No big, dramatic judgment, just a bureaucratic note that the court had made up its mind.
The final order was blunt, procedural. It basically said, because Argentina and Chile didn't agree, the court has no power here. The legal challenge is over. And the court ordered the Antarctica cases to be, quote, removed from its list. That's it.
So at the end of the day, the UK's big attempt to use international law just fizzled. It was like a chess game on cracking ice, where two of the players just refused to even make a move. The case was dismissed, not because the UK's claim was bad, but because the court literally wasn't allowed to make a decision. The standoff on the ice? It was still very much on.
And this leaves us with a really fascinating question, doesn't it? This whole story shows us the absolute limit of international law when it comes crashing up against that unshakable wall of national sovereignty. So when the highest court in the world is powerless to fix a problem, what other options are left for a place like Antarctica? What happens when the law just runs out?